provided consultants, services, governmental bodies, and non-government organizations, NGOs, and actively participated
This meeting is being recorded.
cooperative conferences and symposiums. These multifaceted enterprises have significantly enriched his insight into cooperative development and facilitated his contribution to global cooperative policy formulation and implementation. Professor Henry, you are most welcome. Karibu sana.
Thank you very much for these kind words of introduction. Very good morning, ladies and gentlemen. I greet you from Geneva. So also I'm based here at the time we are speaking. I'm in Geneva. I'm very sorry I could not join you over the past 2 days, but I'm happy to share now with you some ideas on the theme of cooperative law and sustainable development. It will be very lawyerish. I'm a lawyer by basic training, so please bear with me. In addition, English is not my native language, so may I be excused for all the mistakes I certainly will commit in my presentation. The objective of this presentation is to justify the following statement. Public international law shapes the substance of organizational cooperative law. Accordingly, cooperative law are only those legal principles, legal rules, and legal practices that translate the cooperative principles as enshrined in the 1995 International Alliance Statement on the Cooperative Identity in a way which allows for the recognition of a cooperative as a legal person, obliging it to contribute to the goal of sustainable development. Now, to justify this statement, the presentation develops, first of all, legal arguments which demonstrate that public international law does indeed shape the substance for cooperative law. It then discusses the sustainable development compatibility of cooperative law, a number of hurdles on the way to such a cooperative law, and it concludes by summarizing the findings and by briefly evoking research on and teaching of cooperative law as a condition for the future development of cooperative law. Now, the first part, cooperative principles, those things which shape the cooperative law. This part clarifies, first of all, the meaning of the term the cooperative principles, and then it demonstrates the existence of an obligation of legislators under public international law to translate these principles. In general, the use of the term, the words, the cooperative principle is not clear. But I think that a systematic reading of the 4 parts of the ICA statement on the cooperative identity, namely the definition of cooperatives, a set of 6 cooperative values, a set of 4 ethical values of the members, and a set of 7 principles, leaves no doubt as to what the words the cooperative principles mean. The introductory sentence to the cooperative principles in the ICA statement reads as follows, and I quote, "The cooperative principles are guidelines by which cooperatives put their values into practice." Read systematically, the sentence reads as follows: "The 7 cooperative principles, as listed and explained in the statement, are guidelines by which cooperatives, as defined in the statement, put the 6 values on which they are based, and as they are separated in the statement from the 4 ethical values of the members, into practice." That is, not only are the 7 principles mutually reinforcing each other and interdependent, but the 3 parts of the whole statement are reciprocally linked. Now, what about the obligation of legislators to translate these principles? In this part, I shall first deal very briefly with the radical criticism of the opinion that public international law could shape national law, and then I shall develop arguments to justify this opinion that legislators have indeed an obligation under public international law to translate the cooperative principles. The opinion that public international law prescribes the substance of cooperative law meets very radical criticism. It expresses mainly in doubts as to whether public international law creates legal obligations at all, and as to whether the principles of a non-governmental organization, the ICA in our case, can be relevant for the legislator. As concerns the first doubt, two main arguments are put forward. Number one, without its transformation into national law, public international law does not create any legal obligation. And number two, without enforceability, public international law does not create any legal obligation. Apart from the first argument being valid only where a jurisdiction follows the principle of duality of national and international law, both arguments fail, as they would allow that actor whose behavior public international law is to regulate for most, namely the state, to decide on the validity of public international law. Lack of transformation into national law and or lack of enforceability leave the validity of public international law intact. The first argument would also lead to a split. Public international law would be binding on states that follow the monist principle and not binding on states that follow the principle of duality of national and international law. The second doubt, can the principles of the ICA be relevant for the legislator, I think is misleading. The objective of this presentation is not to demonstrate that the cooperative principles by and of themselves were legally relevant. The presentation rather claims that sources of public international law establish an obligation of legislators to translate the cooperative principles. And that is now the object of the following part. The question is whether the claim that legislators have an obligation to translate the cooperative principles can be based on a phenomenon which qualifies as a source of public international law. Now, the sources of public international law are listed in the statutes in Article 38 of Statute of the International Court of Justice. And these sources are four. First of all, international conventions, treaties. Number two, international custom. Number three, general principles of law. And number four, court decisions and writings by eminent publicists. In the following, the sources of law listed in Article 38 of the Statute of the International Court of Justice will be discussed in the descending order of their hypothetical degree of relevance for the question we deal with here. So let us see first of all whether we have conventions on which we could base the obligation of legislators to translate the cooperative principles. And there are three texts I think we need to consider. First of all, the 1966 International Covenant on Economic, Social and Cultural Rights, the International Covenant on Civil and Political Rights the same year, and the 2002 Promotion of Cooperatives Recommendation 193 of the International Labour Organization. Let us first look at the two international conventions. The strongest argument to justify the claim that public international law establishes indeed an obligation of legislators to translate the cooperative principles derives from a systematic reading of Articles 1 and 2 of the International Covenant on Economic, Social and Cultural Rights, Article 22 of the International Covenant on Civil and Political Rights, and of the legal principle of the prohibition of contradictory behavior. Now, these two international covenants are very clearly conventions in the sense of Article 38 of the Statute of the International Court of Justice. And the general principle of law that prohibits contradictory behavior is a general principle of law also under Article 38 of the Statute of the International Court of Justice. Now, especially Article 22 of the International Covenant on Civil and Political Rights demonstrates the existence of an obligation to translate the cooperative principles. The argument is the following. If a state does not allow the cooperatives registered by its government to join the ICA, the International Cooperative Alliance, as a member, it violates their right to associate, protected under Article 22 of that covenant. If, on the other hand, a state allows the cooperatives registered by its government to join the ICA as members, it must allow them to respect the Articles of Association of the ICA, which contain the cooperative principles. Now, these Articles of Association are legally binding on the ICA, on its members, and also on the members of these members. If the government of a state does not allow them to do that, it violates the principle which prohibits contradictory behavior. Consequently, the law of that state has to be aligned on the text of the ICA statement, as its cooperatives would also have to respect the national law of that country. If it is not aligned, that state must exempt these cooperatives from the application of the cooperative law to the extent necessary so that they may respect the Articles of Association of the ICA. The consequence would be a national cooperative sector split into two types of cooperatives, cooperatives which are organized according to the text of the ICA statement, and cooperatives which are not. The margin of that state to decide whether or not to align its law on the text of the ICA statement would, however, be slim, because not to do so would be, by all probability, in contradiction with the fact that the government has previously voted in favor or at least acquiesced international instruments with a similar content as that of the ICA statement. Now let us look at the ILO Recommendation 193 as a possible source of public international law. Now, with some modifications that are not relevant here, the ILO Recommendation 193 on the promotion of cooperatives integrates the text of the ICA statement. Its paragraph 10 states the following, and I quote, "Member states should adopt specific legislation and regulations on cooperatives which are guided by the cooperative values and principles set out in paragraph 3, and those are the values and principles of the ICA statement." The question is whether this paragraph 10 of the ILO Recommendation 193 constitutes a legal obligation for legislators. Apart from my own articles I wrote on the question and where I answer affirmatively this question, the question has not been dealt with so far. General comments on the legal nature of recommendations of international organizations lead to conclude that paragraph 10 is not legally binding. And the word, the denomination as a recommendation would indicate that. However, as is the case with other denominations of instruments of international organizations as guidelines, decisions, resolutions, etc., the denomination of the Recommendation 193 is not more than an indication for its being or not being legally binding. One might, of course, object the following. Had the ILO wanted to make Recommendation 193 undoubtedly a legally binding instrument, the International Labour Conference would have had the choice to adopt a convention under Article 19 of its constitution instead of a recommendation. However, this objection unduly petrifies the initial legal nature of Recommendation 193. The legal nature of international instruments may, and often it does, change over time. It is not static. And for most, the International Court of Justice is not bound in its assessment of the legal nature of an instrument by the initial legal status of that instrument. The assessment of the circumstances of a specific recommendation may lead to another result, and that is exactly the case of Recommendation 193, and we can maybe in the discussion, if you're interested, I can give you the reasons why I think that the specific way of adopting this recommendation makes it a legally binding instrument as far as cooperative law is concerned. Now, where this opinion that our recommendation is legally binding as far as cooperative law is concerned is not shared, I think we still have to consider the fact that a growing number of regional and national laws does refer to the principles. So it would be the burden to argue against that would be on the side of the legislator who does not want to follow what is written in the Recommendation 193. Now let us look at another source of public international law on which we could base this obligation of legislators to translate the cooperative principles. And I'm considering now a general principle of law, general principles of law recognized by civilized nations. And I can see two of these principles which we need to discuss. One is the equal treatment principle, and the other one is the legal principle of sustainable development. The legal principle of equal treatment first. The question is whether the ongoing trend to approximate the structural features of cooperatives with those of capital-centered enterprises through legislators violates the principle of equal treatment. This trend might not so much concern the laws on cooperatives, but it does concern many of the other elements which constitute cooperative law. And I come back to that. However, this trend would only violate the equal treatment principle if that principle required having cooperative law in line with the cooperative principles. Requiring not to treat cooperatives in law in the same way as capital-centered enterprise types is not equivalent to requiring treating them in line with the cooperative principles, unless one gave the sociological uniqueness of the cooperative principles such a decisive weight, or unless one were to agree that ILO Recommendation 193 is legally binding as far as cooperative law is concerned. Now let's have a look at the legal principle of sustainable development. The discussion on whether sustainable development is a legal principle, a legal concept, a paradigm, or at least a principle of interpretation and or whether it is a goal, whether it can be defined, and if so, how, etc., might not conclude anytime soon. In its first decision on the matter, the International Court of Justice recognized in 1997 already sustainable development as a concept of public international law. Later on, as an objective, the arbitral tribunal classified it as a principle. The fact is that sustainable development is becoming part and parcel of instruments which are recognized as sources of law, from international and supranational conventions and treaties, national constitutions and laws, to the legal discourse in general. Sustainable development gradually permeates all law. It has evolved into a legal principle and goal, and I think a human right to sustainable development is emerging. Now, in order for a principle and goal of sustainable development to qualify as a source of public international law, the translation of the cooperative principles would, however, have to be the only means to comply with this principle and goal, and that is not the case. Now let us look at another source of public international law, and that is international custom as evidence, and I cite here from the Statute of the International Court of Justice, international custom as evidence of a general practice accepted as law. The preliminary result of my ongoing scrutiny of 70 national and 4 regional laws on cooperatives has revealed a large variety as concerns this inclusion. It may be categorized as follows: laws on cooperatives that include the cooperative principles literally, laws that include them with modifications, either by adding or by subtracting principles, or by adding wording to or subtracting wording from them, or by including the explanations that go with the principles in the ICA statement, or by modifying these explanations. Laws that refer to the cooperative principles, and laws that reflect them without mentioning them. In addition, it is not always clear whether the included cooperative principles are those of the ICA statement or not. Now, because of that variety, these inclusions of the cooperative principles into regional and national cooperative laws, because of this variety, this does not form a common pattern. Hence, this practice does not, I think, qualify as a custom as required by the Statute of the International Court of Justice. The assumption is that the scrutiny of all laws on cooperatives would not change the result. In addition, it cannot be ascertained whether the inclusion of the cooperative principles in the laws on cooperatives is driven by the opinion that this practice is accepted as law, which is a second requirement for it constituting a source of public international law. But an even stronger argument against the qualification of the inclusion of the cooperative principles in national and in regional laws on cooperatives as a custom, in the sense of Article 38 of the Statute of the International Court of Justice, is the circumstance that the law on cooperatives is just one element of the cooperative law. In most, if not all countries, other elements of the cooperative law are modeled on capital-centered enterprise types and do not translate the cooperative principles. And finally, the last source mentioned, public international law, mentioned in the statute, to have judicial decisions or teachings of highly recognized publicists. And the answer is no. We have a certain number of high court decisions around the world, India, Argentina, also the European Court of Justice, but these are not, it's not a sufficient number of court cases which would allow us to derive from that a source of public international law. And as far as publications or the works of recognized publicists is concerned, as I said earlier, there is hardly anything in the literature to be found on the question of whether we have public international law dealing with cooperative law. Now let us look in the third part at the sustainable development compatibility of cooperative law. Now this part argues that democratic participation is the most effective mechanism to generate social justice as the central aspect of sustainable development, and that member democratic participation is a cooperative meta principle which allows cooperatives to effectively and efficiently contribute to the goal of sustainable development. The central of the four aspects of sustainable development is social justice globally. Put simply, without social justice, political stability is at risk. Unstable political situations lead to economic insecurity. Economic insecurity diminishes people's concern for the biosphere, as they will concentrate on the satisfaction of their economic needs. The most effective mechanism to regenerate social justice is democratic participation in the decisions on what and how to produce and how to distribute the produced wealth. Neither the corporate social and societal responsibility obligations of all enterprise types, nor the requirements laws on the social and/or solidarity economy might establish for the structure, might establish for the structure of actors in the social and solidarity economy are as far-reaching as is the member democratic participation in cooperatives. While the corporate social and societal responsibility and the social and solidarity economy laws focus on the results of behavior, the sustainability compatibility engendering democratic participation in cooperatives results also from the legal structure of cooperatives. In addition to and beyond a number of other structural elements which also contribute to the sustainable development compatibility of cooperatives, democratic participation permeates as a meta principle the cooperative principles in their totality. Member democratic participation does not only permeate all of the mutually linked cooperative values and principles, it also reveals from the definition of cooperatives as contained in the ICA statement. The definition reaches beyond mere participation in the sense of being part of, having a share of, or controlling, etc. The definition which you find in the ICA statement reads as follows. A cooperative is an autonomous association of persons to meet their common economic, social, and cultural needs and aspirations through a jointly owned and democratically controlled enterprise. While it explicitly sets the cornerstones for member democratic participation, the common economic, social, and cultural needs and aspirations of the members cannot be determined otherwise than through a democratic process, and the control of the enterprise must be democratic. The definition also hints, albeit covertly, to a radical notion of member democratic participation. Now, this radical notion reveals when we ask, do cooperatives serve their members as the principles explicitly and implicitly and the bulk of the literature suggest? And the answer is no. According to the wording of the definition, not the cooperatives, but the members themselves serve themselves jointly by means of the cooperative enterprise. The definition reads insofar, cooperatives are associations of persons who meet their common needs and aspirations through an enterprise. This reading qualifies the members as co-entrepreneurs, a position beyond that of participants. It qualifies member democratic participation as a meta-principle which permeates all aspects of the cooperative principles. Now, however, this reading is not compatible with the status of a legal person, should that be sought. As legal persons, cooperatives must be more than the sum total of their members, and this requires reducing the member status to that of participants. This reduction must find then, however, compensation in the widest possible interpretation and implementation of the meta-principle of member democratic participation. The dilemma is that this reading of the definition and of the status of cooperatives as legal persons creates a series of problems which in most jurisdictions remain unsolved. For example, who is to be income taxed, the cooperative or the members? How can labor law apply to or in cooperatives? What about consumer protection law and warranty law, etc., etc.? In addition to these problems, the legislator will be confronted with other hurdles on the way to a sustainable development compatible cooperative law, and that is the object of the following part. Now, this part deals with two aspects of the content of the obligation of legislators to translate the cooperative principles that might require particular attention, namely the meaning of translation and the transition from the cooperative principles to law. The obligation to translate the cooperative principles is often construed as meaning unifying the cooperative laws. Notwithstanding a possible need for and the feasibility of such unifications, translating the cooperative principles does not and must not mean the unification of cooperative laws. It does not mean the unification of the cooperative laws for two reasons. Firstly, because the discussed sources of public international law do not promote the idea of unification of cooperative laws. Secondly, the proper of principles is that they allow for a plurality and diversity of derivations, as long as this plurality or diversity of derivations does not void the unity of the sense of the principles. Translating the cooperative principles must not mean the unification of cooperative laws, because the legal principle of sustainability presupposes the possibility of a diversity of cooperative laws. Diversity in its two aspects, biological and cultural, is the only source of development. Now, how do we transit from the cooperative principles to law? And this part deals first with the interpretation of the cooperative principles, then with the transition from knowledge principles to law, which challenges the modern enterprise world it poses for the implementation of the meta-principle of member democratic participation, and finally with the notion of cooperative law. Can you still hear me? Can you hear me?
Yes, Professor, loud and clear.
Okay. Thank you. Thank you. Thank you. Now, the interpretation of the cooperative principles will depend on the answer to the question whether, by their inclusion in the mentioned instruments of national, regional, and international organizations, the cooperative principles become principles of the respective jurisdiction, or whether their external authorship, that of the ICA, can be considered. Exceptionally, national on cooperatives explicitly stipulate that the cooperative principles included in them are to be considered principles of that law and will be interpreted as are the legal principles of the respective legal system. The same must apply to national and regional laws in which there is no hint to the external author of the cooperative principles. Where, on the other hand, the ICA is explicitly or implicitly mentioned as author of the cooperative principles, the question is whether such external authorship can be recognized, whether the interpretation has to follow that of the ICA subsequent to the adoption of the ICA statement in 1995, and what would be the effects should the ICA decide to change the text of the statement and or the text of its articles of association. Should the recommendation 193 of the ILO on the promotion of cooperatives be recognized as a source of public international law, establishing an obligation of legislators to translate the cooperative principles, then its case is of particular complexity. It is commonly held, and as this presentation seems to have insinuated so far, that the ILO recommendation reproduces the four components of the cooperative identity as enshrined in the ICA statement. This is, however, not the case. The differences between the text of the ICA statement and the relevant paragraphs of Recommendation 193 of the ILO raises doubts as to the authorship of the cooperative principles as contained in the ILO Recommendation 193. These doubts are reinforced by the divergent references to the authorship of the principles. The annex to the recommendation mentions the ICA, whereas paragraph 3 of the recommendation mentions not the ICA but the International Cooperative Movement as author. In addition, the legal status of annexes to instruments of international organizations is not clear. Now, how do we do this transition from non-legal principles to law? In addition to the aforementioned interpretation issues, it is not clear how to transit from the principles to law. The cooperative principles are not legal principles. Generally, principles and values, moral, ethical, or others, enter the reign of law through legal principles. It will be the task of the gradually emerging cooperative legal science to develop cooperative legal principles that compel cooperatives to contribute to sustainable development and which would either form a subgroup of legal principles or an autonomous set of legal principles. The task is all the more cumbersome as the use of the terms values and principles in the ICA statement is not consistent and as it differs from that in scientific disciplines. For example, the ICA statement classifies democracy both as a principle and as a value. And while also being notions of ethics, the ICA values of equality and equity and solidarity are also universal legal principles, as is the value of democracy. Now let us look at the implementation of the cooperative meta principle of member democratic participation. Operationalizing the member democratic participation in today's cooperatives faces challenges which were unknown to the cooperatives for which the laws and objects of the Rochdale Society of Equitable Pioneers were crafted and from which the cooperative principles developed over the history of modern cooperatives. The laws and objects of the Rochdale Society of Equitable Pioneers were based on the idea of a unity of the governors and the governed, a unity which still transpires through the definition of cooperatives as explained earlier. Since then, the world of enterprises has changed and continues changing. The main changes, I think, are structural changes of cooperative enterprises brought about by the factors of globalization. Now, these changes prompt the need for a reinterpretation of the meta principle of democratic participation. Its adjustment requires reconceptualizing the places where participation should take place, the participants, and the modes of participation. Now, the places of participation are determined by the new variants of cooperatives, multi-stakeholder, multi-purpose, a mix of public and private, etc., etc. The circle of participants must encompass members and possibly other non-member stakeholders without transforming cooperatives into public service organizations or into charities. As for the mode of participation, deliberative modes of decision-making must be explored. Virtual participation using latest secure technology must complement physical participation. In addition, enterprises of all types, cooperative enterprises included, change from being singular entities linked operationally to each other by contract to being organizational elements of more or less permanent global horizontal and vertical value chains. Some of the chain links are structured hierarchically, some heterarchically, some like cooperatives in a combination of the two. Some of the chain links or of the value chain dissolve into global, ephemeral, and amorphic, deorganized networks of actors, connectives. It is unclear how the meta-principle of member democratic participation can materialize in such chains and networks composed of different enterprise types, subject to different national and or regional laws, and where the value chain are not regulated by any law, but rather by the terms and conditions of the value chain leaders, and where the networks are probably not regulatable by law, but are increasingly regulated by algorithms. Finally, the notion of cooperative law. The use of the term cooperative law, the words cooperative law, throughout this presentation covers at least three aspects which require consideration. Firstly, the notion of cooperative law, and I've mentioned that several times, it's much wider than that of the law on cooperatives. It comprises all sources of law, such as laws, administrative acts, court decisions, jurisprudence, cooperative bylaws, statutes, etc., etc. All those rules and practices which shape the organization of cooperatives. So again, just to summarize, when we say cooperative law, we often refer only to the law on cooperatives, but the notion is much wider. We have to consider this much wider notion of cooperative law to get a full picture of what regulates cooperatives and what should be changed if we think of changing the cooperative law. Secondly, the individualistic notion of law, I think, is a problem, and that we more and more have in our discourse a very individualistic notion of law, which is probably not adequate for what we are trying to do here. The core of cooperatives is solidarity, and if you want to express solidarity in legal rules, you need a specific notion of law, which is not the same as we would use it, for example, for capitalistic enterprises. And thirdly, it will not suffice anymore to only consider state law, including by extension regional and international law. Other than state laws do also regulate cooperatives, such as, for example, laws based on religion, customary or so-called traditional laws, standards set by private actors, the laws in the informal sectors, and others. They exist in most states, and they either modify the state law or they apply effectively in its stead. Furthermore, where the members of a cooperative do not share the same culture, the practice of that cooperative will alter the cooperative law of the state, and where, as mentioned, cooperatives integrate organizationally into global value chains, the practice of cooperative law of the state which regulates them will be impacted, as these value chains are meeting points of various cooperative laws and of various laws on other enterprise types. Now, taking other, that's my point, taking other than state law into account without ignoring the central role of state law, not the least because of the enforceability mechanisms it provides, is a means of making cooperative law more effective. It is a sign of taking the people-centrism of cooperatives seriously, and it allows to construct out of the various perceptions of justice, of which laws should be the most reliable expressions, the necessary global social justice as the central element of sustainable development. Let me conclude. The following discussion resulted in confirming the existence of an obligation under public international law to translate the cooperative principles as enshrined in the ICA statement on the cooperative identity. This translation meets a number of complex hurdles, whether in the face of radical changes such as the de-organization of actors and the increasing regulation by algorithms. The idea of cooperatives can still be institutionalized through law will depend in the end, for most, on whether cooperative law will again be made part of research and teaching. Thank you.
Thank you. Thank you. Was we just switch this name. This one is reference. Mike, microphone, sir. Yes. Thank you. Thank you very much, Professor Henry. You have heard the presentation of Professor Henry. And this shows that what I said about him is in fact true. And the concept, the Latin word, recepta loquitur, the thing speaks for itself. We have heard him sailing through the international conventions, the ILO, international cooperative principles, the cooperative principles, the cooperative values, and he came. That is why I will call upon you to look at, to situate cooperatives and the cooperative philosophy, and maybe come up with another school of cooperative, Ujamaa Cooperative School, which is about the concept of cooperation, which is the life of the cooperators, living together, working together. The enterprise comes at the end, the business comes at the end, but the socialization is the core aspect. And this has a lot of bearing in our culture. I now therefore call upon the participants. I now therefore call upon the participants to come up with contributions, questions, if any, comments, etc. You are most welcome. Yeah, it is you. Yeah, it is you.
All right. Professor Hagen, can you hear me? Is it there? Okay. My name is Ajib from Nigeria. I'm a member of the ICA committee. Now, I want to thank you for the depth of work you've done, not only for your presentation, for the good works you've done on cooperative law in over a quarter of a century. Is this position correct?
Oh, okay. Then I don't need to hold. Okay.
Do I still need to
Do I still need to use the microphone?
Okay.
Okay.
Good afternoon.
Good afternoon. Good morning, sir.
Yeah, your boy.
Yeah, your boy.
My name is
Achibola
from
Nigeria.
Thank you for your
presentation
and for
all the good works you've done over the years.
Some of
us have cited you over and over and over. And you are the river from
which you drink from.
Now,
My
question is,
last year
in Belgium,
we had a session
at the CCR Global Conference in Norway. And
the primary
focus
of
that session was on
the teaching of
the teaching of cooperative law
in the university.
And you rounded up your presentation here today with the question of whether cooperative law should be part of education and research.
Now, much has been done on
cooperative law
by you,
by the late Professor Walker.
But one thing I
think is missing,
and I have a
strong conviction
that I am not
being subjective,
is
in the promotion
of
cooperative laws
in
the various tertiary institutions.
Now, one completely missing link, and which is an offshoot of the problem I've identified is the complete negligence of cooperative procedures. Law is in two parts, the substantive part and the procedural part. Virtually all the works on cooperative law have been on substantive cooperative law to the total
neglect of procedural cooperative law. I would like to throw it to respectfully, sir. Have you
at any point tried to promote endowments, fellowships, etc. around the world on cooperative law? That, I think, will go a long way towards the integration of cooperative laws to curriculums, the various
faculties
at the law schools.
Thank you, sir.
Well, thank you, dear friend. It's nice to see you. As you might, if I may respond immediately, as you might imagine, I fully share your concerns. In fact, there are two things. Cooperative law is not researched enough, and it's not taught. And if it is researched and taught, it is focusing on the substance, and we do very little on other elements of cooperative law. Now we're trying hard. We, meaning some of our colleagues, including yourself, we're trying hard to convince our colleagues who teach whatever they're teaching, law in general or enterprise law, that they also would include cooperative law. This will take time, but I'm confident that we get there eventually. It is a matter of not having a sufficient number of colleagues who have the necessary knowledge to teach, and you normally teach only that which you were taught yourself or which you try to learn yourself later on. So we do not have a broad basis of people who would be able to even teach and research cooperative law. But that is a flaw, and if we cannot really address it and remedy that, then I think what we're doing here is sort of in vain. Yeah, so we're trying. We have approached the International Association of Law Faculties on the matter. We have made some progress. ICA, ILO also. We are trying to get the UNESCO involved in convincing them that the subject needs to be included again in the curricula. And on the formalistic side, as you know, I mean, the ILO recommendation 193 has a clause in paragraph 8, which says that states should include the subject of cooperatives in the curricula at all levels. So, yeah, I follow you. I fully agree. Much more needs to. The notion of cooperative law. It's not enough to talk about the substance. We also have to look into how law is being made, how it's implemented, how it's interpreted, etc. All that, in my view, forms part of cooperative law.
Thank you very much. Thank you very much, Professor. Next.
Yes, Professor. I think I can throw at least a question or two to Professor Hagen.
Okay.
If permitted.
Well, yeah, I mean, from my side, please go ahead.
We,
All right. I'm sorry I cannot hear you speak.
can you hear me now?
Yes.
Yes, I'm saying, foremost, I appreciate your presentation. It's been very resourceful, and I think we've grasped a lot from it. Number two, I want to communicate some important information as part of the efforts that you've been doing. I must say, we at the Moshi Cooperative University, we distinguish ourselves because of among other areas, because of the cooperative law in terms of training, research, and consultants. So we've actually cooperative law courses into our Bachelor of Laws curriculum, Master of Laws curriculum, and even non-degree curriculum. So we have started, and we think maybe in some of the some of your endeavors to working with the international organizations, you can think of maybe lessons or providing experiences by at least working with the department insofar as curriculum and the teaching of cooperative law is concerned. My question is, from your presentation itself, is replicated some of the statements that you made. One, cooperative principles are not legal principles. We have to develop cooperative legal principles. Now, you also mentioned, you started your presentation looking at Article 38 of the International Court of Justice Statute, providing for the sources of law. And my understanding is that we have customary law as part of, or international customs as part of. Am I audible, Prof?
Now you again, yes, I lost you in between.
Okay. Yes, I was. So, about Article 38 and the fact that it includes international customary law. Now, looking at the cooperative becomes law because of, among other reasons, long-standing usage and practices. how do you find that? How uh, how principles that are long standing, that have been for a very long time applied to each and every part of the constitutions. And you are saying that they are not the legal principles. In the case or a possibility that these principles have acquired the peremptory norm
Have stopped.
so proper the sources of law. I hope you've gotten that question. As it sails through.
For me, I think I understood, but I'm not quite sure. The quality is very bad. The quality of the technical. So if I on the first part, thank you for the information on law being taught at your university. Yes, and there are some other universities who do indeed, but overall, unfortunately, overall, we must say that in general, corporate law is not taught. But yes, I will keep this as a shining example and mention it if possible. Now, coming to the question of whether if I understood correctly, you seem to say that the fact that legislators have been referring to the corporate principles over a long period of time that constitutes a source of public international law. Well, this is what I would like to establish. As I said, this ongoing work, I'm looking into 70 national and 4 regional laws on cooperatives to find out whether we can, say with certainty that the way they integrate the cooperative principles into their texts constitutes a practice, a custom practice and that would constitute a source of public international law. So far, I've been a bit, I did not really have the courage yet to say, yes, there is such a custom, customary practice, but I would like to, I still have to go further into into the scrutiny of these laws. And my hope is that I come up with a positive result saying, well, you know, there is so much reference to the Cooperative principles now in the text that this constitutes a custom accepted as law, and that is a source of public international law. I was just careful not to say, sort of prematurely come to a conclusion, because the references you find in the laws are they're very different from place to place, from text to text. So that needs a bit more work. But I hear in what you say an encouragement to go on and yes, come up with the result saying that there is enough evidence now that there is a practice which constitutes a source of public international law. But thank you for the comment.
Thank you very much.
Thank you very much, Professor.
Professor Claudia, if you can come to the podium, that will be great.
Yes.
Professor Claudia, please come to the podium.
Is it working now?
Yes.
Yes.
But you need to be here so that you can be visible.
Hello, good morning. Hello, Dr. Hagen. I'm very happy to hear And I wanted to raise an issue about the world economy as it is today, the 19th handing economic globalization. So, and a couple of questions. So, when you were talking about the ICA principles and how they would apply internationally, and then about the value chains and the challenges of how coordinate decentralized value chains, or even centralized ones. Well, I agree. You have had a very important work on national terms and how cooperative law is applied nationally, where we have governments. But globally, we don't have a global government. So, of course, we don't have law that can run across value chains that work internationally or transnationally. So, global chains or supply chains are coordinated by institutional arrangements. So, what we call also standards, ISO standards, IFRS, fair trade standards, environmental standards, and so on. And then different actors, even if they are led by one main company, this is on the basis of institutional arrangements. The same goes with common resources, as Elinor Bostrom and others have proved. So I would like to know on which way do you think that global value chains or regional chains cannot be coordinated on the basis of standards? Because I do think the ICA principles are work like standards, like they are basic standards on which they different actors come together and they make institutional arrangements according to local context. And then same goes with other standards. So how do you differentiate the ICA principles as standards, basic standards, from others that come from civil society and businesses? Like, for example, IFRS and so many others that actually regulate and complement the local and also global economy. Thank you.
Well, thank you for the comments and the questions. You know, if I had an answer to these questions, I would be very glad. These are all open questions, and I think at least I couldn't find any answers so far. It's a very wide range of issues which you mention here. First of all, yes, there are institutional arrangements, there are standards, and most of the time things work out well. But there are two issues. I mean, lawyers are not so much concerned with a situation where everything works smoothly. The question is when there is a conflict, who decides and on the basis of which rules. This is the question, and that is where law comes in. And the other issue is, of course, when we say standards, especially standards which sort of regulate, let's say, the supply chains, who sets these standards? There are many actors involved in value chains, and not all have the same negotiating power when it comes to setting the standards. There is, especially if we look at, specific case of food value chains, there is a huge power imbalance between the value chain leaders and most of the individual farmers who would be attached to that or involved in that value chain. So this is a concern. Who sets the standards? How can we find a balance between the interests involved? So I'm just thinking aloud because as I said, I have no answer. But there was one point which you raised. What is the difference between the standards of the ICA statement and other standards we have? I think the what distinguishes the ICA standards from the others. This is a very very general remark now, because there are many others. I think the ICA standards are very unique. First of all, they have a very long tradition. I mean, it's more than 200 years. And it is, I think, a rather unique case where theory and practice have been working in parallel. I mean, the standards came up after the first corpus had been established. I mean, there was some thinking before, for sure. So in a reciprocal process of practice and theory, theorized practice, practiced theory, we have arrived now at the ICA statement of 1995, and that is under discussion, as you know, again. So it will be further interpreted, maybe changed. Who knows? It's a living thing, and I think no other enterprise group, if we take cooperatives as enterprises or organizational type, has such a unique history and such a unique process of making standards and applying them. And applying them also in the sense of having enshrined them, having written them into their own articles of association. Now, coming back to the value chains again, this is, I think, an issue which we have to look at, we meaning now the lawyers, much more closely, because much of what they're doing is, in fact, escaping law, because you cannot reach that which happens in these chains by the traditional national or even regional law. So we have to invent something new. If we think that there is a need to regulate, but I think there is a sense not to regulate in the sense of sort of limiting them, but to making sure that the involved interests are equally and equitably represented in those standards. I'm sure I did not give a sufficient good answer to your very pertinent question.
Thank you very much.
Thank you very much.
Professor Henry, we thank you for your presentation. Over time, we are using cooperative principles and values as the working framework of our cooperatives. And these have been translated into suit in different situations and customs. Cooperative principles and values are not laws. Laws have a different way of formulation. These are international arrangements, and they have been agreed upon by cooperatives and cooperatives movement, locally and internationally, so that they will as identity. You identify your association is identified as a cooperative society. If over and large, it fits in that framework. And that is why I said at the beginning that Cooperation is a way of life. And if you look at in terms of the African context, it has a relationship with the culture, the cultural values of Africans. Assisting each other in cases of difficulties without pay. The moral. So it is not only about the business. It's about life. And this corporate, in my opinion, are institutions of the cooperators, people. The institutions are there to assist people in the realization of the their cooperation. And having said that, I thank you for your participation. This is not the end of the discussion. We can discuss it outside. And when we go home, we can also discuss and exchange ideas. Thank you very much. Thank you, Professor.
I have to thank you for the interest and the invitation, and I wish you all well for the rest of the conference, but also beyond that in your professional and personal life. Thank you very much.
Okay, we have a few announcements to make. First, all presenters who have paid their registration fee, please submit the paying slip to Dr. Kweka. And those who are yet to do so, please do so before the closure of this event today. Again, all rapporteur and session chair should submit report to Dr. Kweka so that presenters can get feedback timely. Office of Internationalization and Partnership is ready available to engage in a discussion with individuals and organizations who wish to collaborate with Mosh Cooperative University. You can contact me anytime for further information. Global community have announcement to make, and I take this opportunity to welcome Pamela Kaburu for that.
Thank you so much. Good morning, ladies and gentlemen. I only have one very simple task. As we mentioned the other day, we will be having a side event, a worker cooperative side event at the Ushirika Conference Center on your way as you head towards the exit of the university. And I'm here to invite you. Please join. We'll have an opportunity to board a bus outside here, and together we can go and enjoy 2 to 3 hours together. Asanteni sana.
Okay, thank you so much for those announcements. We are now going for health break of 30 minutes, and thereafter we will proceed to the breakout sessions. Sokoine, lecture room 1, Dr. Kalesho will be chair. Again, lecture room number 2, Sokoine, Alphonse Mbuya will be the chair, while in seminar room number 3, Dr. Michael Ngara will be the chair. Again, in seminar room number 6,